Hi, guys. I hope you can hear me. It's Christine Van Gyn from the Canadian Constitution Foundation. Thank you to everyone who is tuning in. I am back in my hotel room from Ottawa after a really long second day in court. As those of you who are tuning into this, I'm sure you all know, that's why you're watching. We are in federal court yesterday, today, and tomorrow. And the court is hearing our challenge to the Trudeau government's use of the Emergencies Act in response to the 2022 Freedom Convoy. And the case is being heard by Justice Mosley of the federal court in Ottawa. A fun fact is today that we learned that Justice Mosley has a Class A trucker's license, and he used to be a commercial trucker in southern Alberta. Like, my mind was like exploded when he said this. I had no idea. It was not anything that I expected. And he actually said it's kind of ironic for him to be hearing this case, but he's probably the only one in the courtroom who actually has ever been a trucker. So I thought that was funny. Let me know what you guys think of that in the comments. Today was obviously the second day of hearings. Yesterday, we heard from the Attorney General a little bit, but it wasn't on the merits. It was on a preliminary motion, this stupid motion that they brought saying that the case was moot. And then we heard yesterday from a group called Frontline Nurses, and then we heard from a group, the Canadian Civil Liberties Association. And I have a video that I posted yesterday summarizing what happened. So if you want to catch up, you can go and watch that video after this live stream is done. So even though those other organizations and us were all in the same courtroom at the same hearing, we have all brought our cases separately. And we also brought it separately from a group of individual applicants who were also heard today. But the court is hearing everyone together because, you know, the issues are largely the same. So today, Tuesday, is it Tuesday? Yes. Oh my goodness, my brain. So today was us starting at 9:30, the Canadian Constitution Foundation. And we made arguments for about 2 hours, and our lawyers did just an amazing job. I'm going to tell you guys what happened today. But before I do that, before I give you this summary, please remember that nothing in this is like a verbatim quote. It is not for attribution. I'm not directly quoting either the judge or the lawyers. I'm just giving you my best recollection based on my notes. And this is also just a description of the hearing and what happened, unless I specifically tell you that it's my opinion. So let's get to what happened today. Our lawyers are Sujit Chowdhury and Janani Shamuganathan. And in this, in today, Sujit went first. His submissions were about the legal threshold for the Emergencies Act, and Janani's were about the charter. So Sujit split his own hour to make three main points. I always like it when lawyers do this, when they give the court a roadmap of what they're going to argue. I think it's a really great advocacy style. So Sujit said that he's going to make these three arguments. His first was on the reasonableness standard. That's the standard of review that the court uses in assessing whether Cabinet's decision to invoke the Emergencies Act was justified. They ask if it was reasonable. It doesn't have to be correct, which is a higher, different standard. Sujit said his second submission was going to be about evidence, and his third was going to be about the last resort clause, this part of the Emergencies Act that requires it be used only when no other laws are available. So starting with reasonableness, the CCF, that's us, we agreed with the CCLA, the Canadian Civil Liberties Association, who made submissions yesterday saying that Cabinet is constrained by the statute. That was one of their big arguments they made. And Sujit, for the CCF, called the Attorney General's claim that Cabinet gets exceptional deference. He said that that claim is breathtaking. Now, while Cabinet is at the apex of executive power, its powers are still constrained. And that is set out, and Sujit cited a very famous case called Roncarelli and Duplessis. It's a very, very famous case. Sujit argued that the reasonableness review must be calibrated based on the scope of power granted to Cabinet. The best way to characterize powers given to Cabinet, in this case, in the Emergencies Act, is they're huge. He said that they're a de facto constitutional amendment. The Emergencies Act allows cabinet to do things it otherwise couldn't, like enact their own criminal laws without recourse to parliament, just, a new criminal law by executive order. And he said that the origins and text and history of the Emergencies Act support the conclusion that the statute constrains the power of cabinet to invoke. The court, he said, needs to draw a contrast between the Emergencies Act and the War Measures Act to help to do this, to help the court do this. He presented a table comparing the two pieces of legislation. And in that table, you can really see that the Emergencies Act is a repudiation of the War Measures Act, which he said was abused by previous governments, most famously, I think, by this current prime minister's father. Although it was also abused by governments before that. I'm going to try and pull up a copy of this little chart. I don't know if you guys can see this. I have it on my phone. I can't share my screen on this, but here is, I don't know if you can see that at all. So this is the chart that we presented to the court. I don't think you can read it. I can't get it to unblur. No. Okay. Sorry. It's a chart that sets out the differences between the War Measures Act on one hand, this vastly powerful piece of legislation, and the Emergencies Act, which was enacted with all of these special ways to constrain how it could be used. And you can't see it in the chart because I can't show it to you, but he said, even in the most superficial comparison, you can see that the War Measures Act included very few specific statutory constraints, whereas the Emergencies Act contains a dense framework of multiple statutory constraints. And Parliament's intent in enacting the Emergencies Act to replace the War Measures Act wasn't just about reform. It was about an entire paradigm shift away from this law, the War Measures Act, that was thinly drafted and an enormous grant of power, versus the Emergencies Act, which is light years away. There are two major contrasts. First, the triggers that authorize the different acts. In the War Measures Act, there's a single trigger. It's things like war, invasion, or insurrection, either real or apprehended, but none of those are defined. And in contrast, the Emergencies Act has a three-pronged trigger: last resort, types of emergencies, and threat to the security of Canada. To compare, one law is built with multiple hard checks on cabinet's power, the Emergencies Act, and the other has very few. That's the War Measures Act. And our factum also shows that the origin of these provisions and how they were strengthened during the course of committee when the Emergencies Act was being developed. The original version of the Emergencies Act, when it was a bill, it didn't define national emergency. And that actually led to it being criticized by not just opposition parties, but politicians and civil liberties organizations and all kinds of different advocacy groups. They were criticizing the bill for having that lack of a hard check. So the draft was amended. During committee, the government then actually listened and they added what would become Section 3 of the Emergencies Act. That's the definition of national emergency. There's also a whole legislative history around the last resort clause. That's that part of the Emergencies Act that requires that no other laws are available. And when you look at that history, you see Minister Beattie at the time, he actually offered proactive amendments to committee based on some of the concerns of civil liberties groups like us, although we didn't exist at that time. But it was argued when even these proactive amendments were not enough. And that's how the last resort clause came to be. So yes, this morning in court, Sujit, our lawyer, pulled up these quotes from committee and from Hansard. And in one quote from the legislative history, it was asked if the government would need to show that other laws like the criminal code were not enough. And the government, to quote them, said, yes, that's exactly right. And that's super relevant here in this case, where the criminal code was not exhausted before the Emergencies Act was invoked. So our lawyer, Sujit, was arguing today that the Emergencies Act actually anticipated what Vavilov, that is the guiding precedent right now on the standard of review, that it anticipated what Vavilov requires, and that it was actually part of the legislative intent of the Emergencies Act. So Here, Justice Mosley interrupted to ask a question. He said, as you know, the Attorney General argues that the court should not put too much weight on legislative history. How do you respond to that? So our lawyer, Sujit, responded by saying it's a part of the modern principles of statutory interpretation to consider the legislation's history and purpose. And this was a very well thought out piece of legislation. He went on to say that, there was a reckoning after the War Measures Act, and the government was very careful in what they wanted to replace it. The government took feedback from the public and from civil society organizations, and the feedback all went in one direction: to add more explicit constraints. So the court here today should give weight to that and to Parliament's intent. Another piece of context is that the Emergencies Act empowers Cabinet to restrict liberty, which in this case, Cabinet did when they implemented the emergency measures that restricted assemblies and the financial measures that froze bank accounts. And the Federal Court of Appeal has held in previous cases where a decision is of great significance to individuals, the decision maker should provide more justification or explanation. So all of this speaks to the amount of justification that's required and the level of deference as it goes to reasonableness. Then Sujit, our lawyer, said that he wanted to turn to an issue that he said he believes is on the court's mind, and that's the relationship between the CSIS Act and the Emergencies Act. And Justice Mosley says, yes, that is of interest to me. Now remember, this is this question over threats to the security of Canada. And the Emergencies Act says that that term has the same meaning given to it in the CSIS Act. And of course, we know CSIS did not think that a threat to the security of Canada existed, but Cabinet still decided to invoke, even though that is supposed to be a part of the threshold for invocation. So this is a really big question before the court. So Sujit explained that Cabinet's determination that there was a threat to the security of Canada was unreasonable because Cabinet had insufficient evidence to reach that conclusion. Since CSIS said that no threat existed and there was no alternative threat assessment, and an alternative threat assessment was actually promised in that notorious invocation memo that Privy Council office sent to the Prime Minister, but no second threat assessment was ever prepared. That's that memo. This is the one that we've talked about a lot. The one from the clerk of the Privy Council, a woman named Charette. She gave this memo to the Prime Minister, giving advice about the invocation of the Act, and it had all these different inputs. Well, in that memo, the clerk said the government would prepare a threat assessment, since CSIS said that there was no threat to the security posed by the convoy or the protests across Canada. But no second threat assessment was ever prepared. It never actually happened. So we've brought this up in our written arguments. And in the responses, in their responses to this, the Attorney General of Canada has said there was no legal duty to prepare an alternative threat assessment. It was maybe a nice to have. Well, today we made 3 arguments in response to that. We say that the alternative threat assessment wasn't just nice to have, but actually legally required in the face of CSIS's finding that there was no threat. And Justice Mosley interrupted here to ask, what is the magic to this second threat assessment? It was in the PCO memo, but on a larger scheme, if Cabinet had a range of inputs about what's going on, does it need to wait for the second threat assessment? There's nothing in the statute that actually says that. And he said, it would have been perhaps sensible, but was it required by law? So our lawyer, Sujit, responded that we think it was required. It would have been open to Parliament to cut and paste the CSIS Act definition without also saying, has the meaning assigned to it in the CSIS Act. They could have used it as a template, but made it clear that it was not the same, that it was a different definition. They could have not linked it that way. But, Parliament could have chosen this variety of different options, and it chose the option that linked the acts. And that, we say, has concrete legal consequences. So the effect of that interlinking of the 2 pieces of legislation is not to make CSIS's decision binding, but if Cabinet disagrees, they must point to other evidence. And we have no evidence of what that input was, since, they said that the threat assessment was going to be that other evidence, and then they never did one. So here, Justice Mosley asked another question. We have the invocation memo, but what about the minutes from cabinet? And Sujit said, so I'm sorry, I'm thinking of another part, but Justice Mosley question was about the invocation memo. Why wasn't that enough? And Sujit replied, the invocation memo was statements. It was not evidence. The fact that it itself says an assessment will come is evidence that the government knew that another threat assessment was required. So Sujit, our lawyer, then asked the court to draw an adverse inference when cabinet delegated the decision to the prime minister to invoke, and when cabinet agreed not to follow the CSIS's assessment, that had this requirement that another threat assessment needed to be provided. And Sujit pointed out that the Privy Council office, in the morning that this was happening, they were scrambling. The Privy Council clerk, Charette, had emailed senior people that morning to ask for another threat assessment. And the memo to the Prime Minister said it was coming, but one was never done. So Sujit argued that all of this taken together, the legislative history, the memo, the conduct of the Privy Council office, as well as the government's assertion of privilege, that we can't see any of these deliberations, they wouldn't let us examine the evidence in the decision-making process. All of that together should lead us to the conclusion that an alternative threat assessment was required. And the fact that one wasn't done, Sujit, for us, argued that that is legally fatal. Then Sujit moved on to the last point that he was going to make, which was about the last resort clause. Now, remember, the last resort clause says that the Emergencies Act can't be invoked just because it's helpful or useful or expedient. It needs to actually be necessary. And the test of necessity is that ordinary law cannot effectively deal with the situation. And we've gone through the legislative history that shows that this was intentionally created as an additional check introduced by Parliament. So to hammer this point home about the last resort clause not being met, Sujit pulled up the Section 58 explanation. Remember, this is the explanation provided to Parliament by the government for why they thought the Emergencies Act needed to be invoked. So Sujit pulled this up. It's this 14-page document prepared for the House of Commons, and he went through it just to show just how lacking it was. He took us to page 13 of that explanation under the heading Conclusion, and it just simply said about why an emergency was being invoked, that the situation, to quote, cannot be dealt with under any other law of Canada. It's half a sentence in a 14-page document on why the laws of Canada are not effective. And that's it. We get half a sentence about why this is necessary. That half sentence renders the government's determination that the last resort clause was met totally unreasonable. The common law on judicial review of any decision maker, including cabinet, requires a real and genuine analysis of why a statutory criteria was met. Whatever deference the government might be given for acting quickly, this half assertion is not it. It is not enough. It isn't an analysis at all. It is just a bald assertion. It is just a restatement of the law itself. So Sujit then took the court through the case law for the proposition that cabinet was required to go through a genuine analysis. And in fact, an explanation is actually required by the Emergencies Act itself. That's the whole point of a Section 58 explanation. The law requires a copy of the Declaration of Emergency together with an explanation for the reasons. And as we know from Vavilov, the leading case on the standard of review, the statutory context here, Section 58, that informs the requirement of reasonableness. And under Section 58, the government owes a duty for a complete explanation about why the last resort clause wasn't complied with. And They just didn't provide it at all. There's no analysis whatsoever. So here Justice Mosley had a question. He said the purpose of the Section 58, as he understands it, is not as the sole explanation. Other material has been filed in these proceedings. And what can he draw from the limits of that Section 58 explanation? So Sujit replied that it relates to reasonableness. And Justice Mosley asked again, but this emergencies happen quickly, things had to be done rapidly. The assumption is that there will be hearings and debates on the government's explanation. Section 58's explanation is an important document, but it's not the end of the discussion, right? And Sujit replied that in the record before us, the Section 58 explanation is the main document that speaks to the last resort clause. None of the other documents speak to it directly or provide an analysis of what exactly what the last resort requires. And Justice Mosley asked, what about the incident response group minutes, these cabinet minutes? Don't they also speak to that? Well, they don't. So Sujit replied, we look forward to being pointed to any portion of those unredacted minutes that engage the last resort clause and explain it, because we don't see it. And remember, a lot of it has been redacted. So when it comes to last resort, Sujit, our lawyer, says that he can explain to the court what we would expect to see if this criteria of last resort was met, to show that all other laws are insufficient. And he pulled up a list of a few dozen criminal code offenses that were arguably at issue during the protests and blockades. And he said there are many, 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 many laws of Canada and in the criminal code that prohibited conduct related to the convoy. There was no absence of legal authority. The AG, the Attorney General, has said that these are just, hypothetical charges. But Sujit assured us that they are not, and we all know that they were not. There were a lot of criminal code charges laid. I think some 200 and no, that's wrong. There were 290 bank accounts frozen, but there were many, many criminal charges laid. And the court in Ottawa also issued an injunction. And of course, it's a criminal code offense to disobey a lawful court order like an injunction. So the injunction actually transformed breaches of bylaw, municipal bylaw, into criminal code offenses. So there was absolutely no shortage of prohibited activity under which charges could have been laid. So Sujit explained that actually the best evidence that the criminal code was up to the task is the fact that existing criminal law powers were the tools that were used to clear out the protests and blockades. If Cabinet had concluded that the criminal code was insufficient, they needed to provide an analysis of some kind about why the injunction or the criminal code were insufficient. Maybe there's an answer, but you can't uphold the decision as reasonable unless we see that answer, and we haven't. So with the remaining time that he had, Sujit turned to what he called the elephant in the room, and that is about this issue of the Ottawa police being overwhelmed. And he said the fundamental question is whether that, being overwhelmed, meets the requirements of the last resort clause. And Sujit explained that the existing law was sufficient, but capacity was not. And the solution to that is to deploy more police. It does not mean that the Emergencies Act threshold has been met. And to show how this deployment could have happened under existing law, Sujit brought up the RCMP Act. And there's been a lot of talk, especially at the Public Order Emergency Commission, that the RCMP is not the local police in Ottawa. And yes, that is true. Although there are a lot of RCMP here, they are not the police of jurisdiction. They are not the local police. But it's nonetheless true that under the RCMP Act, officers have a duty to engage in and perform duties regarding the prevention of crime. So, it might be an exceptional day when the RCMP would have to exercise that power, but it's there, and nothing suggests that RCMP officers were not available. So if an RCMP officer has the power to arrest someone committing a crime on Wellington Street, right where the protests were taking place in front of Parliament, the fact that they don't do that as a general practice may be true, but they can, and this was an exceptional moment. So nothing explains why it wasn't done in this case. So then we took the break and we came back, and our second lawyer, Janani Shanmugatnathan, made arguments about the charter. She opened by saying that the Emergencies Act measures violate Section 2B and 2C of the charter. That's the right to freedom of expression and freedom of assembly. And the financial measures violate Section 8, which is the right to be free from an unreasonable search and seizure. And she also said that these violations can't be saved under Section 1, which is the balancing part of the charter that asks if a right has been violated, whether that violation is justified. And we also adopted yesterday, the CCLA made some submissions on Section 7, right to life, liberty, and security of person. And we also adopted those submissions. So let's get to what Janani argued on Section 2. She said that Section 2, freedom of expression and assembly, a breach here is pretty clear. The question is more about whether or not the breaches can be justified under Section 1. And she argued that the regulations, the emergency measures restricting assemblies, that they were drafted so broadly that they captured people who didn't create blockades, people who had no intention to create a blockade, and people who might not even support blockades. She said it prohibits assembly that could reasonably lead to a breach of the peace, as well as traveling to such assemblies or materially supporting them. So the scope of the prohibition that stops peaceful, it means it stops peaceful assemblies, even if you're not doing anything that amounts to any type of disruption. The emergency measures prohibited assemblies, and it meant that you couldn't even go to an assembly where specific harms, like blockades, were taking place, even if you were not engaging in those harms. In fact, the measures prohibited you from going to an assembly where those harms aren't even taking place, but where they could. So she gave some examples. She said, yes, it captures truck drivers parked in Wellington and refusing to move, but it also captures a person standing peacefully on Parliament Hill holding a sign. They're just standing there, expressing their disagreement near where someone else is disrupting the movement of traffic. Even if that person standing peacefully on the grass doesn't agree with the disruption of traffic, they still could face 5 years imprisonment. This was the same problem with the prohibitions on travel to areas where specified assemblies or prohibited assemblies were taking place. It captured a person walking over to a place where another person is blocking traffic, even if they had no intention of joining, or even if they disagree with the disruption of traffic. The measures also prohibited providing property to someone participating in one of these prohibited assemblies. This is what she calls the aiding provision. So the prohibition captures someone who brings water or food to a protest where someone else is disrupting traffic, or even giving water or food to a person walking to a protest where a disruption hasn't even happened yet. All of those people are captured. So these are all people, I mean, in most of them, they're all engaged in peaceful political expression, and their only relationship with people causing a disruption, like blocking traffic, is just being at the same event. And she said that those prohibitions violate the rights of peaceful protesters. So as Janani said, there is a Section 2 breach. The question is about whether the breach is justified under Section 1 of the Charter. And she said that on Section 1, the regulations cannot be justified because they are not minimally impairing. They could have been drafted to stop blockades, but not to violate the rights of people who are not involved in blockades and who don't intend to form blockades. Janani then went through a few different ways that she says those regulations could have been more narrowly tailored. For example, by carving out a space for peaceful protest. I'm here in Ottawa, there's still some people who are protesting. They don't have vehicles, and they should be permitted to continue protesting in this form, even if the government doesn't like it. So then she took the case for the court to some case law to show how this could have been done, how it's happened in other cases. Here, it's been done before. But here, in this case, we had a prohibition that grouped in everyone together, whether you intended to cause harm or not, and there's no zone of permissible protests as there were in these other cases that she took the court to. She said another way that the regulation on assemblies could have been more minimally impairing would be if they limited them to just blockades. So instead of making it a prohibition on assemblies where a blockade could happen, they could just prohibit blockades. She showed the court a blockade ban that was imposed in Nova Scotia as an example. But we don't see that type of narrow tailoring in the emergencies measures in this case. Then she took us to another example from Ontario that honed in on the problem that the government was trying to solve, which in that case, again, was also blockades. And in the Ontario regulation, they narrowed the scope of the prohibition to the actual problem. It didn't criminalize all these people just tangential to it. So the third way Jenny says the government could have limited the prohibition and make it more narrowly tailored is with respect to the travel prohibition. Instead of a broad prohibition that the government created, they could have said, you can't travel to an assembly to create a blockade or participate in a blockade. But they didn't do that. They captured all of these sort of people on the sidelines. I won't use the term fringe because I think that prime ministers kind of used that word, but I mean the people who are not directly involved in actually impeding traffic. Now, the government could have done other things. They could have narrowed the aiding provisions that prohibited, giving water to people at blockades or people intending to create blockades. Or they could have actually defined what it means to participate in a prohibited assembly. There is no definition. And as a result of all of these failures, the prohibition on assemblies really captured a lot of legitimate speech. It chilled a group of people who have a right to engage in peaceful protests. So here, Justice Mosley interrupted with a question. He said, what about having peaceful protesters who might have gotten carried away with the zeal of the people who were participating in the blockades? Or what about the people who were, standing, not participating, but their presence might be encouraging those who were participating in blockades? And Jenny responded that the onus is on the Attorney General to explain why they needed that group of peaceful protesters to get at the particular harm of blockades. The onus is on them to show why they needed to get at everyone, not just the people doing, something specific like border blockade or a road blockade. She added, we have to remember that the regulations also gave police additional power, for example, to enlist the help of tow trucks. So the Attorney General needs to tell us why they couldn't just use that additional power of enlisting tow trucks with all the other existing criminal code powers, why they also needed to create this large net to capture people who were not engaged in a specific harm like a blockade. So that wrapped up Jenny's submissions on Section 2. She then turned to Section 8 of the Charter, which deals with privacy rights and reasonable search and seizure, and how that right was violated by the financial measures. In particular, Jenny wanted to focus on the disclosure provisions, which had the police giving information to the banks and the banks giving information to the police. In these submissions, Jenny said there are two issues. Was there a search or seizure? And does it comply with Section 8 of the Charter that requires searches and seizures to be reasonable? On the first issue, Jenny said clearly the disclosure provision is a search. And people have a reasonable expectation of privacy about their financial accounts. The Attorney General is not denying that. So in order to comply with Section 8, the search must be reasonable. So how should we look at the scope of the search power? Is it broad or narrow? And here, we at the Canadian Constitution Foundation, we disagree with the Attorney General. We say that the scope is broad, and they say it's narrow. The Attorney General describes the scope of disclosure obligations on banks, in particular property that belongs to a person involved in the blockades or related transactions. And we say this is a mischaracterization. The Attorney General is tying the involvement in the blockades, tying the searching of accounts to participating blockades, when in fact, that's not what the financial measures say. The financial measures are directly tied to the emergencies measures, which are a lot broader than just people participating in the blockades. And those two measures go hand in hand. The emergency measures prohibit people from participating in an assembly where a breach of the peace could reasonably happen, or aiding or traveling to such an assembly. So that means that the financial measures could also affect those people. So who does it capture? The Attorney General says only people involved in blockades, but as I've said, tying it to blockades isn't actually in the orders. It just says designated person. So it would cover banking information of people just standing on Parliament Hill holding a sign, or someone walking to the Hill to hold a sign. And it could also even cover the banking information of someone giving water to someone to walking to the hill, giving water to someone walking to the Hill to hold a sign. So that person's banking information could also have them. They could also end up a designated person and have their banking information searched. So what's the big deal with banking information? The Attorney General says there's no big deal. They say it's just simple banking information that is disclosed, but we disagree. Banking information includes all kinds of things. It includes information about the types of accounts you have, how much money is in them, the transactions in the measures, the orders. They're not limited in time to just the time around the blockades. It's actually all transactions of all time through the history of the account, and it deals with the future transactions as well. That's a huge amount of information. It's information about how you spend your money, how you waste your money, where you go for coffee, if you see a therapist, who your therapist is, what organizations or churches you support, where you go to the gym, if you go to the gym. That's a whole lot of information just from bank accounts, all kinds of really important biographical information that goes to the core of who you are. And these measures tell banks that they need to tell all this information to the police. This is profoundly intrusive, and it goes to the biographical core of Section 8 rights. When you look at this disclosure provision, it's also more criminal in nature than a regulatory disclosure. This isn't like a regulatory search where the threshold is lower. It's not like a search of business records or things related to securities and investment product compliance. This is a lot more serious. It's backed by a 5-year term of imprisonment as part of the penalty under the measures. So in this case, you could go to jail for 5 years for giving money to someone going to one of these protests. That possibility is covered by these measures. There's also nothing in these financial measures or emergency measures that says that the government can't use the disclosure of banking information to prove an offense under the measures. Nothing would stop this banking information from being given to a Crown prosecutor to prosecute you for a crime related to the convoy. So Jennedy concluded, so this is clearly, it's more of a criminal type search than a regulatory type search is the point that we're trying to make here. So Jennedy concluded by saying that the onus is on the Attorney General to show why they had to take the measures that they did to target such a large group, expose that group to disclosure of very intimate details about their lives instead of taking a more narrow approach. And she said the government is supposed to use a legislative scalpel, not a sledgehammer, and this was a sledgehammer. So that wrapped up our submissions, and we went for lunch. I went to the same place we went yesterday for the salad, the Mad Radish. It was really good. And we ate our salads and we gossiped about the case. Give me a second. I'm just going to have a sip of water. These are long live broadcasts, so I wear out my voice a little bit. So after lunch, we heard from the lawyers for the individual applicants in this case. Some of these individuals, as I mentioned yesterday, actually had their bank accounts frozen by the financial measures. So our organization, the Canadian Constitution Foundation, we were wrapped up for the day, and 2 new lawyers got up. Their names were Blair Ector and Bathsheba Vandenberg. Ector was up first, and he addressed Section 8 and the Charter and economic measures. He also spoke a little bit about Section 1 and the Bill of Rights as it relates to property rights. I'll give you a bit of a summary. I won't spend as much time on it because it's somewhat similar to what we argued, but I'll point out some differences. They did spend a lot of time discussing a case called Hunter and Southam, which is a very important case on Section 8 of the Charter and privacy rights, and it was actually the first case to consider Section 8. There was some back and forth over whether Hector's clients had their accounts seized or frozen. They were affected by the orders. They did have their accounts frozen. For 5 days, they couldn't access them. And Hector said, when it comes to whether they were frozen or seized, this is a little bit semantics because they couldn't access their account for 5 days. They had to rely on the kindness of other people to get them fed and keep them warm in a building. They did not have access to their accounts. And he said that's a seizure, but at a bare minimum, it was a search. And he said that warrantless searches are presumptively unreasonable. Hunter and Southam is good law. It's cited by the courts every day, and it stands for the proposition that a search is reasonable if it's authorized by law, the search was reasonable, and if it was carried out in a reasonable way. And he said there's nothing reasonable about police and banks being the arbiter alone without any appeal or charter rights. The police and the banks are judge, jury, and executioner here. There is no neutral arbiter. If you are a designated person and you have your account frozen, you may have no idea what's going on and you have no way to appeal it. He then turned to Section 1, the balancing test that asks whether a limit on a right is justified. And he said that Section 1 is not met here, that it was not a justified limit because these measures were not minimally impairing and the negative effects far outweighed the benefits. In one of his client situations, this client didn't live in Ontario. His account was frozen. And he said, if not for the generosity of other people, he would have, frozen in the cold in Ottawa in February. So Hector said he doesn't want to make a purely emotional plea in telling stories like this. And he did cite a lot of case law and he responded to the Attorney General's case law. But he said what happened here was wrong. And he asked the court to find that the extrajudicial warrant scheme was unconstitutional and that his client's rights were violated. Next up was Bathsheba Vandenberg, also for this group of individuals. Now, at this point, we've heard from three organizations, one lawyer for the individuals. So Vandenberg seemed to want to try a different approach. Her main submissions were about how the Emergencies Act should be interpreted. And she considered the Emergencies Act preamble and international treaties and customary international law. This was really interesting, but I want to point out that the role of customary international law and international treaties in domestic law, it's a really touchy area. There are a bunch of cases that I don't necessarily agree with, and those cases were cited here, including a case called Hape and a case called Nevsum. It's a really complex area, and I don't think this case is going to turn on international law, but it was interesting to listen to. Her main point, I'm not going to get too much into the details, but her main point was that there's an international law norm of due process, and it was violated here by the financial measures. And she did look at the legislative history around the preamble to the Emergencies Act and gave some excerpts from parliamentary debate to show that the Emergencies Act was meant to be very different from the War Measures Act and have all kinds of constraints on the government. And I think that speaks to some of the points that we made earlier on the standard of review and reasonableness. Next up was the government of Alberta as an intervener. And again, I won't spend too much time on them either, but they discussed the role of constitutional principles and the consultation with the provinces, the federal government's consultation with the provinces over the invocation of the Emergencies Act. Because remember, Alberta said they didn't need the Emergencies Act. So then we had about an hour left in the day. So we heard then for the first time from the government of Canada on the merits of the case. We didn't get too much into the merits, but a little bit. So we heard from two lawyers. The first talked about the context of the protests, and the second lawyer talked briefly about the standard of review. So I'll summarize what the Attorney General said. And remember, this is not me agreeing at all with the Attorney General. We're obviously opposed to what the Attorney General has said here. So I might add a little bit about what I thought of these arguments, but I'll tell you what he said. He wanted the court to remember what it was like on February 14th of 2022 and leading up to it. He said that there were no crystal balls available and there was no way to see what was going to happen next. We just knew what had happened up until then. And the Attorney General lawyer said, what all the applicants here have done today, including us, is engage in hindsight. And that is not how the matter should be reviewed. It should be reviewed about what we knew at the time and the context of the time. He said that over the past 2 days, there's been a revisionist approach. For instance, a lot of discussion about the threats of serious violence, and he emphasized threats. He said you don't need to actually show serious violence because by then it's too late. Sure, but CSIS said there were no threats either. So and there was no second threat assessment done. There's no information about what additional information about these threats that cabinet had when CSIS disagreed. So I don't agree with that point. The Attorney General also said that there was a discussion yesterday that one measure that did fit, that was functional, was the tow trucks, but it was dismissed as some secondary concern. And he said it wasn't. There was this threat of violence against tow truck drivers, and we should be very concerned about that. I will add that during the course of the Public Order Emergency Commission, we learned that the day before the Emergencies Act was invoked, tow trucks were on their way to Ottawa. So I still don't agree with this point of the Attorney General. Then the Attorney General said, we heard a lot from the CCLA, from the CCF, and from the individual's lawyer, Hector, about the financial measures that they were, in the view of counsel, not precise enough, that peaceful protests should have been allowed. And he said, but how are the police supposed to distinguish that? How do police walk into a crowd of tens of thousands with fireworks being set off, as if fireworks were being constantly set off? They were not. And how do police go in there and say, you there, you're peaceful, and you there, you're not? How are they supposed to do that? To which I reply, that's literally what the police do all the time. They walk into crowds, and if someone's being violent, they address the person who's being violent. So to show more of this context that he's been emphasizing, the Attorney General pulled up some testimony from the Public Order Emergency Commission, testimony from the Privy Council Office Clerk Charette, and that infamous memo. And he said her testimony shows what was going on that day. And this was according to Clerk Charette. And in her testimony, she said it was urgent, it was critical, that was beyond the capacity of any individual province to deal with it. These are just bald assertions. This is not any evidence. And she said, it didn't seem there was any province that had the power to deal with it on their own. Again, bald assertion, not evidence. And Charette said, but if you look at the totality of it all, that's what lies behind this advice. And the AG lawyer said, this was the context. Maybe it was the context of Charette's subjective opinion, but it was not a threat to the security of Canada, according to CSIS. And her saying that it was overwhelming it seems to be a subjective assessment. You need to show the inputs. You need to show the evidence of why that was the case, why this measure of last resort was needed. So the Attorney General then discussed how law enforcement and government were concerned about violence spilling over, citing things like Coots. And they said that if things didn't end peacefully, it could create a chain reaction across the country. And he said, what matters is looking at the totality of what was happening. We had a national protest for 2 weeks that overwhelmed police, where despite the existence of statutes, the protests continued, and that all of this was tied to a politically stated objective. In the remaining time, that was it for the first Attorney General lawyer. In the remaining time, the other Attorney General lawyer came up to make submissions on the standard of review. He said the cabinet decision to invoke should get a high level of deference, and cited some case law that, we in the CCLA had cited the exact same case law for the opposite proposition. And the Attorney General said in this case, cabinet was making a declaration and had a delicate balancing based on numerous inputs, working their way all the way up to cabinet. based on a rapid fact matrix about the threat and capacity and shaped by Cabinet's view of public interest. And he said that made it a quintessentially executive and therefore unconstrained. And he said, we're not saying it's not subject to judicial review, but it gets deference. And I fundamentally disagree with that. I think that this would be too much of a grant of power to our executive. It would be too much deference given to Cabinet when we already have an incredibly powerful executive here in Canada. So, the last thing that was kind of interesting was a back and forth that the Attorney General had with Justice Mosley. Justice Mosley asked, what am I to make of the Public Order Emergency Commission report, of Commissioner Rouleau's report? He said he has all the respect for the commissioner and for the difficulty faced by the inquiry, but what weight can he give the expressions of opinion in reporting results in that report? And the Attorney General replied, the report is not a decision of the court. It's an expression of opinion. And according to him, though, he said it should be persuasive on this court. The Attorney General said that they cite the report for its legal reasoning and logic. And if all of that hangs together, he said that should be persuasive on the court. And that was about it. I'm wondering if that is going to be something that is touched on in reply tomorrow. The parties are all going to do a reply. So that was it for today. The Attorney General is going to begin again fresh on the merits of the case, and you can start watching that at 9:30 tomorrow. In the description to this video, I have a link where you can register with the court to watch. And I'm also going to be live tweeting again. You can follow my tweets at CVANGEYN. That's C Van Geyn on Twitter. And just wondering if you guys watched the live stream, and if you did, what you thought. And what do you think of Justice Mosley telling us that he used to be a commercial trucker? I thought that was really awesome, and I thought that was kind of funny. And I was wondering what you guys thought, if you noticed that as well. So thanks for following along. Like and subscribe. If you subscribe to the channel and you ring the bell on these videos, there's a little bell icon. It will let you know every time I'm going to go live. And I'm going to do this again one more time. It might be from the airport tomorrow instead of from the hotel. And the parties tomorrow are all going to do a reply. We're going to do a reply as well. So let me know what you thought. I hope you watch again tomorrow. I have a lot of fun doing these and seeing what you guys think. So it encourages me that so many people watch them and so many people care about this still. I had an op-ed that was in the National Post today about the case, but I think that there hasn't been enough media attention to this particular hearing, and there was so much attention paid to the Public Order Emergency Commission, which it was totally fascinating because we had cross-examinations of people like the Prime Minister, but the outcome of that report was so disappointing. And I'm really hoping that we're going to have a different and better outcome, a more just outcome in this one. So thanks everybody for watching and for tuning in, and don't forget to subscribe to the channel. Oh, and if you want to support the costs associated with the case, we are a legal charity, so you can make a tax-deductible donation at the ccf.ca/donate. All right, guys, thanks. Have a good night.